Good afternoon. Thank you for registering for today's webinar, where we will discuss the very hot topic of sexual harassment. Today's session is going to be led by myself, Andrew Swirling, and my partner, Mary Ann Monroy. Mary Ann and I are partners at Garfunkel Wild. I have over 35 years experience litigating cases from the New York Supreme Court through the United States Supreme Court, and I'm a member of the firm's Employment Law Practice Group and its Litigation and Arbitration Practice Group. My partner, Mary Ann, is the chairperson of the firm's Employment Law Practice Group and also a member of the Litigation and Arbitration Practice Group and a recognized expert in New York State on matters relating to employment law. And between the two of us, we have decades of experience investigating and litigating sexual harassment cases. As far as the subject is concerned, the news is rife with allegations against celebrities such as Harvey Weinstein, Bill O'Reilly, and others, accusing them of being serial sexual predators. And people are amazed at the breadth and longevity of the acts underlying these allegations. But importantly, the medical profession has its own share of sexual harassment issues. In one study from 2016, a third of female physicians reported being sexually harassed. In another study, 54% of medical students stated that they had experienced some form of sexual harassment. And just as significantly, juries across the country are responding with a certain anger to such allegations. One example is a well-known $168 million verdict that was awarded to a California physician assistant. Another example, a $1 million award given to a physician who was found to have been wrongfully terminated for complaining about the existence of sexual harassment. And just one other symbolic example, a $1 million award given to a nurse who was terminated after complaining about an affair between a hospital's chief medical officer and a hospital director. On today's webinar, we're going to guide you on how to identify the more subtle forms of wrongful behavior, the impact on patient safety and the financial viability of your facility should you fail to respond appropriately, and what steps you can take to prevent such behavior and to respond to it in the most effective manner possible. Our presentation is going to last about 30 minutes. We encourage you to use the question box in the upper right-hand corner of your screen to post questions, and we will respond to all questions at the conclusion of the webinar through email. A replay of this presentation will also be posted to Garfunkel Wild's YouTube channel, and we will email that link in the coming days. Again, want to thank you for registering for today's webinar. So now let's begin.
Okay, good morning, everyone. I usually like to start off anti-harassment seminars with giving the audience some information about some of the statutes protecting employees against harassment. In the tri-state area, some of the most significant statutes include Title VII of the Civil Rights Act, the New York State Human Rights Law, the New York City Human Rights Law, the New Jersey Law Against Discrimination, and the Connecticut Fair Employment Practices Act. Needless to say, these laws cover not only sex discrimination and harassment, but other protected categories such as race, religion, disability, marital status. So the sex protection laws fall under the broader anti-discrimination laws. With that being said, we're going to move forward with the topic. The first thing I always like to go over is the legal definition of what is harassment. And I usually start off by saying unlawful harassment is not the same thing that perhaps maybe you have children and your kids harass each other. That is not unlawful harassment, being annoying or personal disputes or things of that nature. Unlawful harassment is linked to a protected category. So as the legal definition points out, harassment consists of unwelcome conduct, whether verbal, physical, or visual, that is based upon a person's protected status, such as sex, race, religion, color, national origin, etc. It also covers pregnancy as well. Just because you might encounter a situation where employees are having a feud or maybe a personal dispute that may not constitute unlawful harassment, it is important for managers and employers to really manage that situation to make sure that it does not escalate where you have one employee then later on claim unlawful harassment and it turns into a potential claim. And we see that happen often, that where you have situations where employees are not kind or discourteous or unprofessional, or between supervisors and managers, that situation, although it might not be related in any shape or form to a protected category, the complaint allegations that later surface all focus on it must be because I am a woman or I'm a man or some other protected category. So it is important that managers intervene when they see these types of disputes happening. Okay, so what is sexual harassment is a subset of the general harassment protections. And again, this is a legal definition, and it constitutes or it arises when there's unwelcome sexual advances or requests for sexual favors, whether verbal, physical, or even visual. And it becomes unlawful when the submission to such conduct is made implicitly or explicitly a term or condition of employment, or a submission to or rejection of the conduct is used as a basis for employment decisions, or has the purpose or effect of unreasonably interfering with the individual's work performance, creating an intimidating or hostile environment. So with respect to number one, where it's an implicit or explicit term of employment, I sometimes give this scenario that you have a situation where the female employee out of a group of a mix of men and women is expected to make the coffee every morning. Now, it might seem innocuous and it's not a big deal, but that is something that I have seen come up in situations where, okay, who's assigned to make the coffee or change the toilet paper in the bathroom? This stuff comes up. So be aware of that. The submission or rejection to conduct is being used for the basis of employment decisions. I usually give the typical example, okay, I'd like you to go out to dinner with me. If you don't do that, and then there's a decision made where the person doesn't get a promotion or maybe a salary increase or vice versa, that would constitute obviously a form of sexual harassment. And the last scenario, some examples, and that falls into the hostile working environment, are things like that are a little bit more subtle that you might not realize, but we've had these situations come up where you're working late at night and some colleagues are working and one person comes behind the other and is rubbing that person's shoulders. And they think they're doing it out of kindness, the person's tired, but then the disgruntled employee who may be terminated a few months later brings up that situation and says, you know what, I was made to feel uncomfortable. That person was constantly rubbing my shoulders within my personal space. I hear that one a lot too. Be mindful of, respecting everybody's personal space, not talking to them too closely. Sometimes if you're too much in someone's face, someone might say it's intimidating or threatening if you're pointing fingers at somebody. Things of that nature. I've seen things come up with if you may have a desk and the computer is behind the desk and people tend to enter behind you. I've heard complaints where someone might feel a little bit intimidated or overwhelmed by someone being that close to them behind their workstation. So again, be mindful of those types of situations. Moving along to the types of sexual harassment, and this is how they usually defined or show up in lawsuits. They're either called the quid pro quo variety, which I refer to as the this or that variety. That's when they are requested to submit to some sexual demand in exchange for benefits, as we discussed before, or the hostile work environment variety. The other thing that you should be keep in mind is most of these types of litigations or claims are couched in terms of I was treated disparately, a disparate treatment claim, meaning that they were treated less favorably than someone who was not a woman, or the disparate impact type of claim. So you might have a facially neutral policy or activity, but in implementation, it winds up favoring one gender over another. So for example, what if you schedule important meetings on the golf course and some of the female colleagues, and golf is not historically or traditionally as played as much as by women, they may feel excluded from participating in those meetings because they're scheduled on the golf course. There may have been no ill intent in doing so, but you have to be mindful if whether or not you're going to conduct an activity, does that exclude one sex or the other from the activity. Okay. The other thing I like to point out, because people get nervous with hostile work environment claims, someone may say something and it's out of character and they never really say it, but they did this one time. There are some defenses there, an isolated remark or comment. There are some defenses to those types of things as long as it's not of the most serious, egregious nature. But again, you really want to manage your staff and have training sessions with them to warn them and be mindful of their communications, because what they say can be taken offensively by employees and used against them in a claim or a lawsuit later on. I also want to review some of the types or examples of harassing conduct. As I mentioned before, they come in different forms, such as physical, verbal, or visual. So physical, most people would think about the grabbing, touching, groping. Of course, those fall into unlawful sexual harassment, but others you might not think of as quickly, where you're having a conversation with somebody and you grab the person's wrist or arm because you want them to hear what you're saying or maybe not leave the room. Those things have been brought up as claims. We've had incidents where people make issues about that, where they felt either intimidated or sexually harassed by having their arms pulled or something of that nature. Brushing against somebody, it might be the person who's doing it might think they're kidding around or being affectionate, and that is perceived as being sexually harassing by someone. I also want to note situations where be mindful if you're having a conversation and it might be a little bit of a heated conversation, or you're critiquing maybe performance and you're blocking the doorway or the exit so that the employee to whom you're speaking to cannot exit the room. This, again, I have seen come up in claims where people will accuse the person or the manager of being intimidated because the doorway was somehow blocked and they felt that they couldn't leave the room. Needless to say, you shouldn't throw objects around a room, or managers should be careful about that with getting frustrated. Slamming phone receivers up and down on the desk can be perceived as intimidating. Throwing computer mouses, and I raise these examples, these are all things we have encountered. Instruments in the OR room, we get plenty of calls. I've never had a call about a scalpel being thrown, but plenty of other instruments that have been in the OR where a physician has gotten frustrated, and it is a very sometimes intense situation, but you have to be careful because the nurses and those around will be quick to say that so-and-so is acting inappropriately. So be mindful of those. As far as verbal, name calling, degrading language, jokes, asking a person about sexual preferences, I also like to point out terms of endearment. Things where, again, you may think it's innocuous or friendly and maybe one person doesn't mind, but not everybody wants to be called honey or sweetheart or sweetie, or even references to, I used to experience this when I first started out in practice, young lady, and sometimes it has the connotation of suggesting of less experience and than the other person who's saying that. So be mindful of those types of comments. As far as visual forms of sexual harassment, I usually refer to things like sexual pictures, obviously, mooning people or dropping or taking off clothing, leering at people, gawking at people, staring at people. That is becoming increasingly more popular, that I hear claims of that nature. I also seem to hear this more in the context of protections for gender identity, individuals who are transitioning to one gender or the other, and people are not being respectful or courteous, and claims are coming up in that regard. So you really have to be careful and train your staff to be respectful of people based on their sex, sexual orientation, and gender identity. Okay, so those are some examples. Next, I want to review a few terms of sexual harassment. We have the term sexism, and that's a set of attitudes and beliefs that prejudges an individual or a group of people based upon their gender. So I usually say, okay, you've heard the phrase of pretty blondes, they must be less intelligent. But it can also come in the forms of you sitting around a table and you're going over your patient cases, and when the idea is posed by a female or maybe by a male, because sex discrimination can be against a male or a female, the same ideas that may be given by the female resident or physician are kind of ignored or trivialized, but then when it's said by another individual, it seems to get more praise or traction. So people should really be mindful of how they may be perceived in engaging in conversations with members of different sexes. Sex discrimination is the next term I want to review, and that's a behavior. It's based upon basing employment decisions on an employee's gender. So the typical scenario there would be not paying equally based upon the same qualifications on the basis of gender. Sex-based harassment is another term. It's a behavior that denigrates or ridicules an employee or is abusive to an employee because of his or her gender. Again, I'm going to refer to transgender protections and using proper pronouns. So, for instance, if an employee is transitioning and you continue to call the person by the former pronoun, that can be considered sex-based harassment, and you have to respect people's choices. Or another scenario, their meetings and the woman colleagues are expected to hang up the jackets and maybe escort the clients into a room or the patients into a room, things like that. Or maybe a job that's traditionally been held more by female employees rather than male employees, and they're not considered as seriously for the particular position because they happen to be of one gender or another. So those are the types of things. I'll give an example of maybe the position is for a medical assistant, and the male applicants, and there might be maybe all female medical assistants in a practice, the male applicant isn't given as much consideration, and that is really, obviously it's unlawful, and you have to be mindful that you're not subconsciously making decisions based upon gender.
Okay, the players in sexual harassment situations. First of all, who can be a victim? Well, the obvious one is the person who is the target of the wrongful behavior, but the less obvious can be the third party who's not the intended recipient of the behavior. For example, someone who merely hears or observes the behavior and finds it offensive. It might be the person sitting in the next cubicle over who overhears something and is bothered by jokes of a sexual nature. Even a person who consents to sexual activity or conduct that can be deemed of a sexual nature can legitimately claim afterwards that they're a victim of sexual harassment, because very importantly, submission to sexual activity is not a defense to a sexual harassment claim where the employee submits due to pressure from the harasser. Who can be a harasser? Well, you have a laundry list. It could obviously be a supervisor, but it can also be peers. So if you have someone from one department who incessantly is asking out someone on a date who is from another department, and that person does not find that to be welcome activity, that peer can be a harasser. It does not have to be someone on the same level within the organizational hierarchy. In other words, a subordinate can be guilty of harassing a supervisor. The gender of the particular harassers are also irrelevant for purposes of deciding or assessing whether or not sexual harassment has taken place. Vendors, people don't often think of responsibilities when it comes to vendors, but if you have delivery people who keep harassing your front office people or any of your employees, asking them out on dates or engaging in even more egregious forms of behavior or conduct that's not of a welcome type, it's your obligation as the employer to step in. Even though that vendor, the delivery person, whoever the person may be, is not your employee, you still have a responsibility on behalf of your employees to either speak to that person, call their employer, have them change their route, whatever it would take in order to stop the unwelcome behavior. It's your obligation to take such action. Contractors, you have people coming and fixing the plumbing and so on. The same rules apply. They can be harassers. Importantly, for assessing who may be a harasser, intent is not a relevant issue in assessing whether sexual harassment is taking place. The only relevant inquiry is whether the impact on the behavior, the impact of the behavior on the work environment. And so oftentimes we've handled cases where someone says, well, I was just trying to be funny. I thought everybody was laughing. I didn't realize that there was an individual or individuals who found my humor distasteful and over the top. It's just not a defense. And when we give out advice in these situations, the basic rule of thumb is if you're unsure, if you are walking in a gray zone, then refrain from that behavior. If the joke that is about to come out of your mouth, you're not certain if everybody in the room is going to find it amusing, then just tell a different joke, or don't tell a joke at all for that matter. The situs, it doesn't have to take place at the work site. Holiday parties this time of year, the volume of sexual harassment cases goes up during holiday time. You get people carrying on at parties, off-site seminars, conferences. A rule of thumb that Mary Ann and I often tell people, skinny dipping at the off-site hotel swimming pool is not advisable. We actually had a case of that type, amplified by the fact when the doctor's wife and children showed up at the hotel to bring him some clothing, only to discover dead in the swimming pool, skinny dipping along with female members of the staff. So not advisable. Who can be liable? The harasser, obviously, but employers are also subject to vicarious liability. Supervisors can be held liable as well if they fail to act and put a stop to it. There's a Flushing Hospital case that is easily found where one of the chief medical officer was also sued for not stepping in when he saw one of the chairs of a department sexually harassing one of the employees. So there's a responsibility down the hierarchical chain to step in if you're any member of management. We included the reference to disruptive behaviors in this seminar on sexual harassment. I mean, it's an entire subject of its own, but significantly, as you can see, sexual harassment is a form of disruptive behavior, as that term is defined on the screen in front of you. And so some of the principles, responses necessary with regard to disruptive behavior are applicable in the sexual harassment setting that we're discussing today. So we just wanted to bring that to your attention. The definition is there in front of you. I won't read it. It's basically been defined as the healthcare equivalent of road rage. Disruptive behavior is a heightened form of inappropriate behavior marked by its severity and persistence, and can include physically threatening language, throwing objects, outbursts of anger and shouting, use of vulgar language, and so on. But again, it can include sexual harassment. Potential consequences, all right? Personal liability, you can get sued. Loss of a job, loss of spouse. We actually handled one case where an employee was sexting and sending photos to other employees. Not only was he terminated, but there was an unfortunate consequence. His wife actually worked at the same company, which caused other implications of magnitude. Loss of reputation, loss of licensure. Physicians, and you see the bottom bullet, OPMC proceedings. Sexual harassment constitutes a form of professional misconduct. So it's possible that if you engage in sexual harassment and find culpable for having engaged in that kind of conduct, it can lead to an OPMC inquiry, which then in turn can lead to a form of discipline and sanction by the OPMC, which can have other consequences as well, such as loss of hospital privileges, for example. Potential criminal charges is another possible consequence if you're the harasser. As far as broader consequences of such behavior, toxic work environment, decreased staff morale, a very significant one, diminution of patient care quality and a greater risk of medical errors. Quality patient care, as most of you know, it's relying on teamwork and communication between staff members, and disruptive behavior such as sexual harassment corrodes those two elements. Likewise, you have as an additional overlay, staff members who are on guard for sexual harassment or otherwise distracted by it or the need to monitor it may suffer from performance problems or even take on the harasser's mindset. You have empirical data that shows a direct link between disruptive behavior, sexual harassment, and adverse patient outcomes, medication errors, and so on. So that's a definite potential fallout at your medical practice if this kind of conduct goes on. Another one, if you have lower staff morale, higher turnover, you're going to have diminished productivity, which is going to lead to diminished revenue, so your bottom line is going to be affected. Increase in staff and patient complaints, and which can lead to a loss of reputation. Again, you may have patients who are going to stop showing up if they know this goes on. Just want to, before going on to practical considerations, throw a couple of scenarios your way just to illustrate some of the common situations that come our way. For example, one of the medical practice's best employees has approached you with a problem. She's being hit on by her department supervisor, but she doesn't want you to do anything. She just wants to go on record as having told someone that this sexually harassing behavior is going on, but she tells you and insists that she's on top of the situation, she's going to take care of it, and she wants you to promise not to tell anyone about it. That scenario we've encountered many, many times. And the answer we tell everybody in response is, once you're aware of it, you have an obligation to step in. Because at the end of the day, what may play out is that if it results in some form of litigation, you can be sure that that individual is going to be able to say that I spoke to Andrew Zwirling on such and such a date, and the questions that Andrew Zwirling is going to be asked at his deposition or at a trial are going to be, what did you do? And so you have an obligation to act. You have an obligation to step in and respond accordingly, to put a stop to the behavior and invoke whatever complaint mechanisms your particular practice or facility has in order to remedy the situation. It might be talking to HR with regard to how you respond to the individual who has now confided in you. You can promise them that you'll try to keep the investigation as confidential as possible, but you can't promise complete confidentiality. And so, that's really setting the tone from inception. A couple of other examples just to illustrate some of the subtleties involved in whether sexual harassment is or isn't taking place. So, for example, a woman, we'll call her Maria, shows up at the office wearing a short skirt, and Bob comments, "Nice legs, Maria." Is it sexual harassment? Very likely it is. Again, it's contextual, but very likely it is. And again, the admonition is, if you're not sure, don't say something like that, because in this particular scenario, the focus was on Maria's anatomy, not on her clothing. What if Susie comments, "Maria, nice legs"? Do you have sexual harassment? Well, again, as Marianne and I said before, the gender of the harasser and the victim is irrelevant for purposes of assessing whether or not you have sexual harassment. A more subtle situation, let's say Bob comments, "Maria, my wife has the same skirt. Do you have sexual harassment?" Well, on the one hand, he's just commenting on her attire, not on her anatomy. But we change the context. What if Bob has incessantly been asking Maria out on a date and he makes that comment? Kind of changes the perception of how you're going to view this particular thing. Or what if Bob is a supervisor and the only female he's making these comments about is Maria? That gets back to Mary Ann's point earlier about disparate treatment. So you can see by these quick little hypotheticals, how difficult the situation may be. But again, if it's a gray area, you step in and you respond.
And given the time considerations right now, we have other hypotheticals, but I think it's important we review some of the practical considerations in dealing with sexual harassment and avoiding it in the workplace. So some of these things are plainly obvious, but it's important that you really train your staff to live by these general rules. Number one, consistently demonstrate professional behavior. And we see this all the time, that the manager or the supervisor who has the hot temper is often the target, because while he might have a hot temper with everybody, or she might have a hot temper with everybody, it makes it much easier for an employee to say, you know what, I was treated that way. I was the receiving end of those rants because I was in this category, whether it's female or race or religion or whatever it might be. I also always recommend that people lead by example. So don't post the funny, quirky jokes on your workstation that have some sexual overtones or other inappropriate things. You don't want to send the message or conflicting messages. You might think it's funny, but you're the manager or the supervisor, and we see these things happen. Don't act out of frustration. Always take a moment to, think something over before you react. If it's going to be an unpleasant conversation, maybe you wait till the next day before reacting to the staff member. Respectful communications, things like, oh, my 5-year-old can do that better or faster or whatever it might be. Refrain from those type of snarky comments, because those, again, they routinely hit the lawsuit. Employees generally will they record things now. They have telephones with them. They're recording as you're making these comments. In years past, they used to keep little journals, and I saw more journals surface, but now I see more and more texts and recordings coming up. So be mindful of what you say could be recorded. Avoid the sarcasm. Don't publicly discipline an employee. That definitely breeds like contention and embarrassment, and will hit or generally does hit lawsuit complaints. Be respectful of cultural diversity, including religious dress, things of that nature. Do not perpetuate office banter, like the rumors. So if you hear something, don't walk over to the next person and say, can you believe what so-and-so said? Those are the things that get you in trouble. Avoid sharing highly personal information of a sexual nature or otherwise. So we hear situations where employees, come in, or managers or supervisors, and they're talking about whatever they did over the weekend with their wives or husbands or whatever it might be, and you run into problems with that. Take appropriate action to stop conversation, or take action to stop inappropriate actions. Don't be the silent participator. If something is happening, and this could be done by managers as well as coworkers and subordinate staff, say, that's not funny, or I don't appreciate that comment. Remember also electronic communications systems, social media, text messages. Those things are all discoverable. And so if you wouldn't say it out loud, don't put it in a text, don't put it in an email, because all these things surface. All the little quirky or quips that you might send by text that could be taken out of context will surface in a claim. So it is important to be mindful of those types of things.
Beyond some of the practical, some of the formal steps that you can take to help prevent sexual harassment and or diminish it if it's taking place. One is, it seems obvious, a well-written employee handbook and policies as well, with anti-sexual harassment provisions. Again, you would think, well, doesn't everybody have one of these in place in today's day and age? The answer is no, remarkably, as we have found out. So you want to have that policy, something to point to, have people acknowledge those policies when they're hired, or when you have regular training on this particular subject area. And it also gives you something to point to should somebody step over the line. It allows you to sit down with them when you're going through the complaint mechanism process to say, look, we told you, here it is. It gives you a starting point for a conversation. Another one, second line of defense, maintaining regular performance evaluations. Oftentimes we see performance evaluations that are really vanilla pudding-like, where everybody gets a 5 out of 5 and there's very few comments and so on. Your performance evaluations really, honestly, should express the good and bad about an employee's performance in the evaluation time frame. With regard to a topic today, if someone has engaged in sexual harassment or has been found to have engaged in sexual harassment, you want that memorialized in their personnel file, because again, it gives you something to harken back to if the behavior reoccurs.
And then just one other thing, I know we're running low on time, but have an effective complaint mechanism. Make sure it's written, make sure it's distributed to employees, visible, it's contained in your employee handbook, that employees know how to avail themselves of that mechanism, know who to report complaints to, and don't trivialize complaints. So if you get someone who comes in and they say, well, I felt uncomfortable or I felt harassed by so-and-so, and you might feel there's no credit or merit to it, you need to go through the steps of addressing it, investigating it, so that you have the file documented, that it wasn't something you ignored. So if it resurfaces a year from now, you have the documentation that you did address it and you undertook your obligations as an employer to maintain a workplace free from unlawful harassment. As far as complaints, make sure you have a process in place and someone who's trained on how to conduct an appropriate investigation. It usually involves interviews, or should involve interviews of involved parties and witnesses. There's fact-finding. You can review relevant materials. As I said before, emails and texts often become relevant, so you want to gather all of that, talk to all people that are involved, you draw your conclusions, and then you implement corrective action as may be appropriate if there's a finding of something inappropriate or unlawful. And that could be things of the nature of additional training, redistribution of policies, suspension, written notices, all the way up through and including termination. And documentation is critical. So when you have to defend a claim, you have the evidence and the proof to say, look, we took this matter seriously. We have policies in place against anti-harassment, and we looked into this matter, and this is what we did. It's the best place that you can be in defending that type of sexual harassment complaint. Also, make sure you have a strong anti-retaliation policy. So if somebody does report a complaint or participates in an investigation, employees are confident or assured that they won't suffer any adverse or retaliatory action for participating in an investigation or reporting a complaint. Uniformly apply your policies. That's also important, particularly with claims of sex discrimination or harassment, and warn employees that violations of the policy could subject them to discipline up to and including discharge.
With regard to the topic of disciplining and discharging an employee, I guess we can't overstate the need to have a credible complaint mechanism. We've handled a lot of cases where the plaintiffs assert that they did register a complaint, but it went nowhere, that the HR department was ineffective, or whoever the person or point person was to receive such complaints. And the failure to have an effective complaint mechanism tends to be a facility's weak spot, because a lot of times we'll have clients say, well, we had an anti-sexual harassment policy, or we did do training on a regular basis. Well, that's fine and necessary, but you also have to have the last piece, which is a complaint mechanism that's going to lead to a proper result, whether either finding that the claim of harassment is without merit, or finding that it is something that's founded and discipline needs to be implemented. With regard to discipline, you have to have the right person do it. Not everybody is wired or equipped or qualified to be the person who has that conversation, which may be of an unpleasant type. Identifies someone who can convey the right message, who won't be excessive on the one hand, but won't be too soft on the other, where the proper message is not delivered if the conclusion is that harassment has taken place and that discipline is needed. Again, that goes to striking a balance. Again, someone who has committed harassment, you can discipline them, but unless you're going to the extreme of terminating that employee, your hope anyway is that they're going to be a productive employee going forward. So you don't want to hit too hard. Again, you want to find a proper middle ground. Documentation, which is true with all aspects of the complaint mechanism. You want to document the disciplinary action in writing, create a corrective action plan so the person knows what he or she must do going forward in order to repeat a reoccurrence of the wrongful behavior.
If anyone has any questions, feel free to input them into the question box, and we'll be able to get back to you later on. We've already run over on time with this presentation, but we will get those questions and we'll do our best to respond to all of them.
Or alternatively, if you feel like just calling us, feel free to do so as well if you think that'll facilitate getting the answers that you need.
Absolutely. Both Andrew and I routinely give counseling and advice to our clients, so a lot of these types of scenarios are fact-specific and are intricate details, and we would be happy to help you through those situations. Well, thank you, everyone. Enjoy the rest of your day. Bye-bye.